This is about the treatment of bonds and photographs under the California Labor Code. Article 2 of Chapter 3 of Part 1 of Division 2 of the California Labor Code concerns bonds and photographs. Section 400 defines an applicant to mean an applicant for employment, and Section 401 specifies that if a bond or photograph of an employee or applicant is required by any employer, then the cost must be paid by that employer. Section 402 prohibits an employer from demanding or accepting any cash bond from any employee or applicant unless the employee or applicant is entrusted with property of an equivalent value or the employer advances regularly to the employee goods, wares, or merchandise to be delivered or sold by that employee and for which the employer is reimbursed by the employee at regular periodic intervals. Section 403 provides that if cash is received as a bond, it is required to be deposited in a savings account in a bank authorized to do business in the state, and it may be withdrawn only upon the joint signatures of the employer and the employee or applicant. Section 404 of the Labor Code states that any money put up as a bond is not subject to enforcement of a money judgment except in an action between the employer and the employee or applicant or their successors, and that the money must be returned to the employee or applicant together with accrued interest. Section 405 states that any property put up by an employee or applicant as a bond is prohibited from being used for any purpose other than liquidating accounts between the employer and employee or for return to the employee or applicant and must be held in trust for that purpose. Section 406 specifies that any property put up by an employee or applicant as a part of the contract of employment must be deemed to be put up as a bond and is subject to the provisions of this law. Section 407 specifies that investments in the sale of stock or an interest in a business in connection with the securing of a position are illegal as against the public policy of the state and cannot be advertised or held out in any way as a part of the consideration for employment. Section 408 provides that any person, agent, or officer who violates any provision of this article is guilty of a misdemeanor punishable by a fine not exceeding $1,000 or imprisonment for not exceeding 6 months. Section 409, the last one, requires all fines imposed and collected under this law to be paid into the state treasury and credited to the general fund. And finally, Section 410 requires the California Labor Commissioner to enforce the provisions of this particular statute.